Talking about contracts, why don't we talk about music contract issue on options, Sandy?
Yes, this is a case, everybody refers to it as the Hawthorne Heights case. I'm not even going to try and pronounce the plaintiff's name.
Hey there, I know it's...
Lovely, thank you. This case is out of the Northern District of Illinois on a motion to dismiss, and it really involves a contract interpretation question. The facts are that Hawthorne Heights, the band, entered into a recording contract with Victory Records, and the contract granted Victory 4 separate consecutive and irrevocable options to extend the contract for to extend the contract term for further option periods. After delivering 2 albums to Victory, the parties had a falling out, and Hawthorne took the position that their agreement with Victory was not exclusive and that they could record for other record companies. They filed an action for declaratory judgment seeking a declaration to that effect, and Victory Records obviously opposed and moved to dismiss. The court held that the absence of the word exclusive in the recording contract really killed Victory. While Victory tried to argue that their options would be illusory because there was no time limit within which plaintiffs must record each album for Victory so that the band could simply deliver album after album to a successor record company before ever fulfilling their obligation to Victory, the court was unsympathetic. The court said Victory did not use the word exclusive and could have. Victory could have imposed time limits for the delivery of albums but didn't. And that the most relief that Victory was getting was the fact that Illinois law implies that performance is to take place within a reasonable period of time. So if at some point down the line Victory believed that an unreasonable period of time had passed since the delivery of an album to it by Hawthorne Heights, Victory was free to pursue their remedies, which is really a pretty harsh finding. But in looking at the defendant's argument, the defendants were trying to claim that the court wasn't reading the plain language of the agreement, and the plaintiffs said that the band had agreed to record 4 consecutive albums for Victory. But the court actually looked at the exact contract language, which said artist grants to company 4 separate consecutive and irrevocable options, each to extend the term for further periods, consecutively, commencing upon the expiration of the preceding period. But the word exclusive is nowhere in there, and consecutive didn't apply to albums, it applied to the option periods. So Victory was really out of luck here and probably is about to sue the lawyer that drafted that contract for not using the word exclusive. Just an idea.
So the court was unwilling to read the word exclusivity into that, even though record companies typically ask for exclusive rights from artists under these kinds of deals. So it's a parallel world that's been created here for the artists.
Yeah, I mean, I don't know if they
and then record for whoever else they want to record with.
Maybe they could have argued that custom and usage in the industry and had an expert come in and said every single recording contract ever is exclusive, but this court was not sympathetic.
Because it did not say exclusive.